And we're going to start with number 195, People versus Marshall. Counselor, do you want any rebuttal time?
Judge, yes, I'd like 1 minute in rebuttal, please.
1 minute. You have it. Go ahead.
Good afternoon, Your Honors. My name is Richard Joselson, and I represent appellant Kaity Marshall. Your Honors, in this case, 18 months after a brief assault on the complainant by a total stranger on a New York City bus, the prosecutor...
Tell us about the picture that was presented to the witness. There was an arrest picture. What was the exact?
Well, here's what we know. What we know was a single photo, and we know it was the prisoner movement slip photo.
So what's the significance of showing a, whatever it's called, the movement slip? What's the significance in terms of the legal case we have in front of us?
Well, what you have...
Why is that fair or unfair to show that picture?
Judge, it's hard to actually imagine a more suggestive scenario. Here you have the prosecutor, who's the chief law enforcement official in the case, calling the complaining witness into the prosecutor's office and showing what's essentially an arrest photo.
What do you think was the purpose? What did the prosecutor want to achieve?
Well, what the prosecutor tells us he wanted to achieve what the prosecutor's notice is, well, I wasn't seeking to obtain or make an identification. What this really was trial preparation.
Why isn't it just trial preparation? What's the consequence, the negative consequence for the defendant?
The negative consequence to the defendant is whatever is going on in the prosecutor's head, whether it's to obtain an identification or whether he simply thinks he's preparing a witness to testify at trial, the result is exactly the same. The witness is being shown, and we don't know exactly what, because for some reason the photo itself was not introduced.
Don't you do a certain number of things in the normal course in preparation for a trial? I mean, is this such an odd thing to have done, or is it?
Well, I mean, look, the prosecutor disclosed it the very next day. I think it is a fairly unusual thing to have done. Look,
Does it make any difference if there's been a previous identification procedure that's been noticed and tested?
Well, there wasn't in this case.
I understand.
In Herner, which is the case that we're really talking about here, there was. I don't think it makes a difference in terms of the question that's at issue here, which is whether there should be scrutiny of this subsequent identification.
But what if, as Stein is saying, is what if there was a lineup or a photo array, or there was some kind of an ID, that was pretty definitive, and then they showed a fuzzy picture. It still doesn't matter?
Look, this would be a different case if there had been a lineup, which had been...
So that would have been okay if there had been a lineup, they identified the defendant, and then in preparation for trial, the prosecutor said, oh, remember, here's the guy, here's a picture of...
Yeah, I still don't think that would have been okay, Judge.
But it would be better, right?
But it would be different from this case. And I understand that this Court, what we're asking the Court to do is to reconsider this whole idea.
Are you seeking a new rule that says, and I think this is what Judge Stein was driving at, that without a prior ID in a more formal sense, that you can't just do this kind of showing the picture in preparation for trial? Is that what are you trying to accomplish? How do we look at these situations in the future?
What I'm trying to accomplish is this.
Aside from what you want to accomplish for your defendant,
right.
I understand
this notion that there is such thing as a trial preparation exception.
Kind of bogus.
I think it was out of step with this Court's identification jurisprudence when it was decided, because the intent.
So is that case wrong?
I think that case is wrong, and we're asking the Court.
You want us to overturn Herner?
Well, I do, and I think the reason I want that to happen is.
What you're looking for is for us to say that if the people are going to go about the business of identifying material pre-trial, that if you believe it's suggestive, you want an opportunity for a hearing on the suggestiveness question, not what their motive was to show the picture.
Precisely. That's where Herner goes wrong. It asks the wrong question. It doesn't matter to me.
Oh, I wonder, though, is this the right case to do that with? And that's one of the – maybe Herner should be challenged. I think it's a legitimate question is whether or not this procedure creates a memory rather than or reinforces a memory improperly. And that in and of itself, I think, is a legitimate question. But in this case, you've got a witness or a victim. I can't remember the lady's name. But anyway, she said that I didn't identify the person from the photograph the way I understood it, and that I couldn't identify them from that photograph. So it didn't establish what would really be, from a policy point of view, the thing that we should be looking for.
Look, I think the problem with the way fact-finding was done in this case was we didn't have a Wade hearing.
Yeah, but do you want anything more? That we have to make any great rules here? You just want a Wade hearing,
I
right?
want a Wade hearing, and let me answer.
What do we have to do to get to a Wade hearing?
I think a Wade hearing asks
to make new law to give you a Wade hearing?
I think you should get rid of this notion of a trial preparation exception.
Well, we're going to have to overturn it if you're going to get a Wade hearing, right?
Do you?
I think, I think not exactly, because I think, look, on its facts, Herner is a very different case from my case. In Herner, it was a picture of a lineup the witness had already seen. It was tested
but do we have to
at a Wade hearing.
eliminate, but that's the question I was asking you, I think what Judge Fay is asking you too. Do we have to eliminate the distinction that Herner makes in order to give you a Wade hearing?
I think I could get a Wade hearing even under Herner. I guess
And
maybe
what would
is
be
what
yeah.
because there was no prior.
I think even under Herner you should get a Wade
Right,
hearing.
but I do think Herner
Okay.
Herner is very problematic, and I don't think the complainant's testimony at this Herner hearing really disposes of the issue
I don't think
here.
so.
Because
they don't rely on the ID. That's why I'm asking.
well, but I mean, she's testifying 6 months after she has this meeting with the prosecutor, and her testimony, it's vague, it's incomplete, and significantly, it is inconsistent with the prosecutor's own pretrial disclosures about what occurred at this proceeding.
Let me ask you about that. This photograph was not disclosed as part of a 71030, right?
It was not.
But it also was never introduced into evidence.
It was not.
And I notice it's not in the record.
It is not.
Why is it not Brady?
Well, if in fact there had been no identification, it probably would be Brady. But I think the problem here is there wasn't no identification. What the prosecutor said when he made this disclosure, he said, look, I brought the complainant into my office. She was giving me.
Can I back you up? Because I think we know the facts. What you say, there was no identification, I think that's Brady. It seems to me if the people show a picture to somebody saying, isn't this the person who assaulted you, and the picture is of the defendant, and they say, I don't know, why is that not Brady?
It would be, but I don't think that's what happened here, Judge. What I think happened here.
Didn't she say, I've not seen the picture?
She
Isn't that
didn't
the point?
really.
I haven't seen the picture.
She didn't really say that. Her testimony is really confused. And what the prosecutor said, and this is the point that I want to make, he said, look, I brought her in. She was giving me descriptions of the person on the date of the incident, on the defendant on the date of her arrest. I was confused about the hairstyle, so I showed her the picture to resolve that issue. And then he says on page A49 of the appendix, on page A49, he said, the witness instructed me about the appearance of the defendant. Now, that's completely different from the witness saying, oh, it was blurry, I didn't look at it. That's a whole different story. And look, the defense got at this below. They said, we have to bring in the prosecutor here. And, of course, there was no earthly reason not to bring in the prosecutor.
What you're looking
here.
for is the Wade hearing with ADA Shook or
Shook.
I can't remember his name. To also be
A
called,
normal Wade.
and this photo.
Exactly, a normal Wade hearing where everyone knows the rules, not this mysterious hearing.
Okay, counsel. Let's
Thank
hear
you.
from your adversary, and
Thank
then
you.
you'll have your rebuttal. Counsel, why don't we give him a Wade hearing?
Camille Gillespie for the respondent.
Why is it not appropriate in this case to give them a Wade hearing?
It's not appropriate because I'd ask the court to keep in mind two very important factors here. The first one is the complainant initially made a spontaneous identification of the defendant involving no police-arranged procedure at all at the hospital. And therefore, there was no Wade hearing required with respect to that spontaneous, not at all police-arranged ID.
But isn't that the point? There was never any testing of any identification in this case.
But a Wade hearing is to test police suggestiveness. There was no issue
Why
of police
couldn't-
suggestiveness
why
with
couldn't it be
respect to that
argued
initial
this is
ID.
suggestive?
Excuse me, I'm sorry?
What could be more suggestive?
The spontaneous initial identification was
No,
not
but
at all
that-
police
That's
ready.
not it. It's the showing of the photograph. Is that a prosecutorial procedure where a defendant is identified?
It was a display at which the witness did not make an identification. She said she
Well,
barely
let me-
glanced
That-
at
that's
it.
what he
Let me
argues
back
is
up
not
a-
clear.
Let me back up a second. If somebody doesn't make an identification, we're back to Judge Pickett's point, which is that that's just as important as if they did make an identification. So, let me finish, and then I'll get you, then you get to it. So the procedure is you got an identification, do you know this person based on this hairstyle? I don't know, I can't tell from that blurry photograph. Then this next day you turn it over, that should all be turned over, and shouldn't that be subject to a hearing?
But not under 71030 and not under Wade.
Why not?
Because if you don't have an identification under Trammell, there's no identification that is subject to, going to be subject to 71030 and the Wade hearing. And second of all, as far as the Brady concern here, in this case, there is no Brady concern because the display of the photograph and the non-identification, these were matters that were known to the defense
Yeah, but wait a
well
minute,
before
wait a minute.
trial.
The picture's not in the record. I don't.
The
Hold on, I'm almost
Sorry.
done. And somebody said it's blurry. Apparently, the witness said it was blurry. I don't know if it was blurry. I don't know. The judge at the trial level doesn't know if it's blurry, because the only one that says it's blurry is the DA, who says, I showed it to her and she said it was blurry. Maybe it's not blurry. Maybe she's blurry. Maybe it's not so blurry that it couldn't have been used by the defense to show that there was a mistake. I just get very nervous about the people having evidence that they make a judgment on and then don't disclose it and then say, well, you know, it's not Brady, it's not Wade, it's nothing. Where did I go wrong in my analysis?
Well, first of all, with respect to the photo, there's no issue of unfairness with respect to the photo. Well, we know that the photo was shown to the court that made the determination. This is the court that decided the Herner hearing issue.
Was it shown to the defendant?
That was in the record.
Was it shown to the defendant?
That it was shown to the court.
Was it shown to the defendant?
I can't say that that's what it says in the record.
Would it seem odd would it seem odd that you would have a photo of the perp and you would show it to the court, but you wouldn't show it to the defendant?
Very odd.
Okay.
It would be very odd indeed. And defendant never claimed that the photo was not shown, even though it was spread on the papers that the people submitted, that the court had been shown the prisoner movement slip photo.
I got the impression that this was almost by accident that word got out that there was this photo, you know, that was shown. I'm almost done. Mr. Joselson wants to do away with Herner. Does that make sense to you?
He wants to do a Herner?
Do away with.
Oh,
Herner.
do away with Herner. Well, it doesn't make sense to me, and in this case, there's no occasion or reason to go that far.
In your argument, too, that we would have to overturn Trammell, too, to get at this case.
Yes, exactly.
What's the point of having a Herner, and why not just have a full Wade at that point?
Well, in this case,
If you're going to have one, why not just do the whole thing and just save a step?
in part because what you had in this situation was you had a prior identification that was completely non-suggestive. It was a spontaneous identification initially, and then later on, when the prosecutor is meeting, as in Herner, makes a brief display of this photograph.
No, I understand the distinction you're making. My question is if you're going to have a hearing, why not just give a Wade hearing?
Because the issue isn't because this court's precedents say a hearing is not required. And in this case,
Why is this not an artificial distinction, this Wade versus Herner? What is that all about? Why does that make any sense?
well, because the ID that counts is the initial ID. And
You keep saying that, but, you know, I've had clients that have confessed that they committed a crime and it wasn't them. But, and in that situation, you'd be saying, they confessed. What difference does it make that they didn't make an ID? They confessed. What difference does it make that they were shown the picture and said it's not him?
Well, but Herner only applies in the situation where there is a prior ID.
I know, but what you want to say, because she positively identified this person at the hospital, it doesn't make any difference if we showed her 50 pictures. It doesn't make any difference what we did. We had a positive ID. This case is over. We're going to put her on. She's going to say that's the person.
Because there's no police suggestion that's involved. That's
I understand
for trial.
that. I understand that. But what I'm saying is, you're saying this case is over. We can do what we want. It doesn't make any difference.
No, I'm not suggesting that. In fact, the court has discretion. Here, there was disclosure. The defendant was, there was no unfairness to the defendant here because he got very prompt disclosure well in advance of trial, and there was an evidentiary hearing.
So what's the rule? It's the Herner rule?
Well, it is the Herner rule, but in this case, this
Why
is
is that something that makes sense going forward?
Let me just point out, though, again, that this was a non-identification, and if the procedure was so...
If we apply Herner to this situation, wouldn't it then encourage the police and the prosecutor not to hold an identification procedure in the first place and just wait and say, oh, this is just trial preparation? Then they don't have to go through a wait hearing.
But I guess the purpose of this, there was no purpose to identify the perpetrator in showing this photograph.
Oh, I think there was. I think what you're arguing is harmless error. You want to say, there was a proper ID a while ago, and it was clear, and that was that. The problem is that if that was true, then the DA would not have had this picture taken of her in transport and shown it to the defendant. There must have been a purpose there.
Well, the purpose, he said, was he was discussing the hairstyle, or trying to understand what the complaint was saying about the hairstyle of the defendant.
But it wasn't that purpose. It was to firm up her ID because you're going to trial.
Well, the purpose was trial preparation, yes.
Well,
but
9 months before you're going to trial. I wish I had that kind of time.
But it wasn't clear at that point that the trial was 9 months down the road.
Judge Stein asked a bit ago, it makes sense to say it's trial prep if, as happened in the real Herner, where there was a lineup before, and now you're getting ready for trial, and you say this is the lineup that you identified the defendant, and that to me sounds like trial prep. When there is no picture before, and this is the first time the person is seeing the picture, that seems to be more along the lines of a weight issue than trial prep. Wouldn't you agree?
Well, but not in this situation where there was a prior spontaneous, not police-arranged identification. That's the critical identification. And this and the
I'm
and
missing
the
that.
time. Let's
assume that that's all true, and that I forget how much time had elapsed between the initial ID and now. There would be no reason for the DA to ask her to look at this picture unless he was concerned about the fact that when she went to trial, when she was going to testify at the trial, she may screw up the spontaneous ID that she did a year ago or 9 months ago or whatever it was.
Well, I think that may be reading a lot more into it than is there. I would simply emphasize that there was no police that doesn't, the fact that there was no police arranged lineup initially doesn't make it worse. It makes it better that this identification is stronger. It involved, there's no question of police suggesting this.
Suppose she gets into court and there's the defendant sitting there and says, is that the defendant? I don't remember.
Then it's possible for, there was additional identification testimony. It would be possible to bring in her identification of the spontaneous identification at the time of the incident.
But wouldn't it help if you showed her a picture?
At the time of the arrest.
Yeah, wouldn't it help if you showed her a picture while she was in transport and have the victim say, yeah, that's the one?
Nobody's suggesting that should be the procedure, but
that might be tomorrow's case, I guess is my point.
Well, and again, to discuss, I mean, just in terms of harmless error, there's no reasonable possibility in this situation that, given that there was no identification procedure, that a court would find that it's unduly suggestive.
But I think you're missing the point of why he's arguing against Herner. You're saying, look, the defendant the victim picked the defendant out without any police officer around, went out on her own and called the police, said, that's the person who attacked me.
Yes.
Right, you say, so police are not involved, that's a good identification, the people don't have to worry about it. But his point, as I understand it, is, yes, but then you have the ADA showing this picture, and in fact, even if the ADA is not thinking about it, even if the victim is not thinking about it, that is having an impact on her memory and what she recalls about the victim, about the defendant. And that's what he's worried about. And that's what he wants an opportunity to get to in a Wade hearing. What has gone on with this photo with respect to what she now may be understanding is the identification of the defendant?
Yes.
Why does that not make some, not only logical sense in the way our jurisprudence has played itself out, but why is that irrational and say, wait a minute, why you're showing a picture the night before, there's been months? It has to affect this woman.
Well, the night before, that's actually what happened in Herner. Is there was the viewing of the lineup photograph on the night before and the morning up. We don't even have that situation.
Well, you had it the day before the hearing. Obviously, the ADA thinks he's got to say something. I know he's a new ADA, but he comes in and immediately puts this on the record, and that's when you have counsel saying, I want a hearing, right? Then he submits an omnibus motion. I want a hearing on this. It could be suggestive. We want to be able to call the ADA. Isn't that the whole point?
And
that's triggered because of the ADA saying the day of a scheduled hearing?
Well, I'm not sure it was the day of a scheduled hearing, but
Well, he's in court for something.
he's, yes, in court for a court appearance.
Okay.
And then the actual Herner hearing doesn't take place until months later.
Sure, because you have defense counsel filing the motion and preparing.
But I just want to stress as well that the record shows that there was independent source, and that.
Aren't you putting independent source before the suggestiveness question? Don't you have to do suggestiveness first?
There's no requirement that be the case. And what Herner recognizes is that the court has the opportunity to craft an appropriate solution. It doesn't require an evidentiary
Should that be what
hearing.
we require, to be an independent source before?
Should it be required?
Yeah.
No, I would say it should not. I think it should be left to the court.
In terms of fairness, why isn't that a better way to proceed?
Well, because it depends on the circumstances. It could be that it could be shown that there was no, that the procedure was not, as in this one, a significant, perceived as a significant display, where the complainant didn't recognize the defendant in the photograph, and also because where you don't recognize the photograph, then that's proof that there wasn't any undue suggestion by the state, and that's what it's
Well, he
issued.
says that's contradictory to what the ADA said. Why isn't he at least entitled to be able to call the ADA? Which apparently the person had been switched out the day before.
Well, following Herner, in that case where the disclosure takes place in the middle of a trial, not
Yeah, there
months
had
ahead
been a
of
Wade
time.
hearing, and then you get to trial in that particular case.
Yeah, there
You
had been a
already
Wade
hearing.
There had been a Wade hearing with respect to the lineup photograph, but with respect to the procedure, it comes out at trial. And here, it comes out well in advance, and that's why it's fair
Is he
here.
entitled to some kind of hearing on the independent source? Or is that completely undisputed?
I would say in this case, that was demonstrated in this record, and the court.
At the Herner hearing?
At the Herner hearing, and the court.
But
The
the
court
court said it wasn't-
considered whether there was any taint of the in-court identification. That's specifically a finding by the court in this case. So that's an implicit finding of independent
I thought the court
source.
said it wasn't going to independent source
No.
unless it held the Wade hearing.
No, and the court didn't actually say, well, this is an independent source finding, but the court found that it did not taint. There was no finding of taint of the in-court identification, both in the court below, both in the, at trial, and also by the appellate term in this case. So you also have a finding by the trial court that the photograph was blurry.
Okay,
So,
Counsel. Thanks. Appreciate it.
thank you.
Counsel Rebuttal.
First of all, there was no finding of independent source in this case, implicit or otherwise, and it would have been terribly unfair for their.
If you go back, 71030, it talks in terms of identifications that they intend to introduce at trial. So if they don't intend to introduce it, they don't have to tell you.
Well, they intend,
Well, hold on. And of course, you had the hospital ID that was going to happen. If he had never said anything about this photo, you would not have known about it, and it would not have affected the trial, right?
well, I think it does affect it. We don't know without a Wade hearing to determine what the effect of this single photo show-up of an arrest photo was. It's a real problem with Herner that could be a thinking that notice of this wouldn't be required.
Well, as Ms. O'Hara-Gillespie is saying, you had a spontaneous ID. That's the person. You know, now, if you'd gone to trial in a week, you know, this thing wouldn't have shown up. So it shows up. He shows her, you know, this picture, which turns out not to be nothing, at least in their eyes. I asked you if it was Brady, and you don't seem to think it's Brady. And I know 71030 they don't have to disclose unless they intend to introduce it at trial. So where does this thing end up?
I think normally because they intend to introduce the in-court identification, they would have to give notice of that out-of-court identification under 71030, except for this Herner confusion. I have to address the spontaneous identification at the hospital. That is no excuse for not having a Wade hearing. I cite the court's case in Matto. That was a case where an undercover officer does a sale. 3 weeks later, he makes a spontaneous identification. He sees the defendant again. The backup team comes in and arrests.
But that's the police.
The defendant, but look what happens. And then after that, the undercover makes a show-up ID of the defendant. And even there, the people argued, oh, he just made a spontaneous ID moments before. You don't need a Wade hearing to test the show-up. And in Matto, this court said, absolutely you need a Wade hearing. And if you need it with an undercover, a few minutes afterwards, you certainly need it in the case
Can
like
I
this.
just ask
Sure, Judge Fahey.
one last question? What remedy are you asking for? You're just asking for a Wade hearing. You're not asking, let me just finish, for automatic preclusion, are you?
No, I just want a Wade hearing, a normal Wade hearing in which the prosecutor the person who did, the law enforcement official who conducted the procedure testifies. The picture that was subject of the procedure is introduced, and the court makes findings about suggestiveness, not trial preparation.
Okay.
Suggestiveness.
Thank you, counsel. Thank you both.
Thank you.
Appreciate it.